If this is your first time attending an NFRPP program, I'm Rhoda Shermer, and I'm the president of the Network for Responsible Public Policy. And no, we were not clairvoyant, and we didn't have a crystal ball. We did know that it was an important topic, but we didn't know it was going to break today. But anyway, we're very lucky to have two fabulous speakers to address the issue of the Supreme Court, and you'll be hearing from one of them soon, and hopefully the second later. I do want to thank our co-sponsors. That's the League of Women Voters of Fair Lawn, the League of Women Voters of Northern Valley, and the National Organization for Women, North Jersey chapter. And I want to thank all of you who were able to contribute tonight, because it's those donations that make this program possible and our future program possible. They defray our costs, and you keep us in business, so keep it coming. I have some good news. We are going to be expanding locations. It's really fabulous that NFRPP programs are in demand, and we are being asked to come to lots of locations. So we will be bringing programs to Camden County, Essex County, Morris County, and Union County in the very near future, in fact, early 2019. And we're hoping to even add more locations. And we're looking forward to meeting new people and being able to educate and inform new audiences. So we're very pleased with that. And we hope if you know people in some of these other locations, that you can advise them to go on our website, web address here, and tell them to sign up, and they'll get notices of the programs that are coming to their area. Tell them we're coming to town, okay? So I'm now going to introduce you to the chairman of our Issues Management Committee, and that's Peggy LaScala, and she's going to introduce our first speaker. So thanks, guys.
Hi, everybody. Okay, I'm Peggy LaScala. I'm serving as the chairperson of the Issues Committee. I'd like to introduce our speaker tonight. It's Bernard W. Bell. He's a professor of law and Herbert Hannock Scholar at Rutgers Law School, the Newark campus. Professor Bell received a BA cum laude from Harvard College and a JD from Stanford Law School. He clerked for Judge Amalia L. Kearse of the United States Court of Appeals for the Second Circuit and for the United States Supreme Court Justice Brian R. White. From 1984 to 1994, he served as an assistant United States attorney in the Civil Division of the United States Attorney's Office for the Southern District of New York. Our second speaker, when he arrives, will be Perry Dane. He's a professor of law at the Rutgers Law School. He was previously on the faculty of Yale Law School, and he served as a law clerk to William J. Brennan, Jr., Associate Justice of the United States Supreme Court. Professor Dane is a graduate of Yale College and the Yale Law School, and here he is right now. His research and teaching interests include religion and the law, conflicts of law, the jurisprudence of Jewish law, legal pluralism, the debate on same-sex marriage, constitutional law, comparative constitutionalism, jurisdiction, the law of charities, education law, and the Canadian legal system. Welcome.
So I'll go first to give Perry a chance to get situated, and thank you all for inviting me to talk about this topic and for the great scheduling of this program, because it's very topical during these times. So I want to start by reading a quote for you, and I want you to guess who said it and when. And it's about partisan politics. Let me now take a more comprehensive view and warn you in the most solemn manner against the baneful effects of the spirit of party generally. This spirit, unfortunately, is inseparable from our nature, having its root in the strongest passions of the human mind. It exists under different shapes in all governments, more or less stifled, controlled, or repressed. But in those of the popular form, it is seen in its greatest rankness and is truly their worst enemy. The spirit of liberty serves always to distract the public councils and enfeeble public administration. It agitates the community with ill-founded jealousies and false alarms, kindles the animosity of one part against another. It opens the door to foreign influence and corruption, which find facilitated access to the government itself through the channels of party passions. So anyone want to guess who said that and when? Pretty close. Jefferson? Actually, George Washington's farewell address, September 19th, 1796. So he was pretty prescient in that comment. So given the level of our politics today, what, if anything, are we to do to have a process of judicial appointments that maintains the legitimacy of the Supreme Court or courts in general? So let me start by talking about a little bit about kind of how we got to where we are today. And to do that, I'll start by making a straightforward observation. Courts are both a necessity and an anomaly in our liberal democracy. They are a necessity because while we embrace democracy, which means the majority rule through legislative representatives, we also embrace individual rights. You can't hear me? Oh, okay. Boy, generally I'm so loud, my students tell me, calm down a bit. All right, so the Supreme Court and courts in particular are taking the role of defending or enforcing individual rights. Moreover, for a democracy to be successful and not a facade, there have to be rules and traditions that allow new majorities to take over. If you can manipulate elections, if you can do that through voting rules or gerrymandering, you can, in a sense, a party can, in a sense, falsify majorities. It can kind of insulate itself from elections and electoral losses. So the federal courts have also served as neutral arbiters of those rules of the electoral process. The anomaly, of course, of the Supreme Court is that it is the most undemocratic institution that we have. Its members are appointed, and they are appointed, at least on the federal level, for life. All right. Now, before the onset of the Warren Court, the Supreme Court had on occasion taken a central role in national politics without tremendously great success. I mean, the court tried to resolve the issue of slavery in the Dred Scott case unsuccessfully, and it also stood against the reconceptualization of the role of the national government and of governments in general during the New Deal, again, unsuccessful. But starting with the Warren Court, the Supreme Court has become central to American politics in a continual and a consistent way. So it's ground zero for any number of social issues, typified by the battle over the right to abortion in Roe versus Wade, but also encompassing same-sex relationships, same-sex marriage, gun rights, the role of religion and religious belief in society. And at the same time, the Warren Court also began assertively taking a role in ensuring rules of fair play in elections, most importantly with regard to one person, one vote requirements that restricted legislative apportionment, but also in its expansion of the First Amendment doctrine, which encompassed a lot of issues involving elections, including, most importantly, campaign finance law. So shortly after Earl Warren retires, a few years after that, the conservatives began a counter campaign to reverse Warren Court jurisprudence and to kind of establish a Warren Court of their own that would embrace a conservative view of society. And they did so under the banner of, and you've all heard it, right? Judges should follow the law, not make the law. Right? And they've been kind of at this constantly even until today. So not surprisingly, confirmation battles have become increasingly bitter. The failed nominations of Robert Bork and the contested Clarence Thomas nomination were significant milestones that fueled partisan anger, but they are not, of course, the only milestones of our intensified partisan approach to nominations. And relatively non-ideological, middle-of-the-road justices like Justice O'Connor, Justice Kennedy are kind of, for the last 30 years, they've been appointed almost by accident as opposed to by design. At the same time, there's been a breakdown in the professional consensus within the legal community, as well as a questioning of professional norms without. And it's not just law that's being questioned, there's all sorts of professions that are questioned. But the manifestation with regard to judicial nominations is that since the 1940s, the American Bar Association's Standing Committee on the Federal Judiciary was pretty much agreed to be a body that would serve a primary role in screening and rating evaluation judicial candidates. That started to come apart with regard to the Clarence Thomas and Robert Bork nominations, because with regard to Justice Thomas, he was given a split rating of qualified and not qualified. And then with regard to Justice Bork, who I guess, Judge Bork, who I guess was the first of the two, he got well qualified from most of the committee, but a four-person group said he was rated him unqualified. So as a result of this and kind of other controversies with regard to the ABA, George W. Bush essentially refused to give the ABA any special role in rating judicial candidates, and Donald Trump has reinstituted that. So that's a kind of short version of how we got here. Now I want to talk about three issues regarding selection of Supreme Court justices and federal judges in general. One question is, should we limit the tenure of Supreme Court justices? Would that do anything to help us in our current dilemma? Second, should we require partisan balance on the Supreme Court or in federal courts in general? And third, should we use nominating committees to select judges, and what might that process look like? So first, let's talk about terms for Supreme Court justices. Now, if you are 45 years old or younger, during your entire life, the Supreme Court has had a majority of conservative justices, right? And we're not going to ask for shows of hands here. If you are, but I would be in that group of over 45. If you are 66 years old or younger, no Democrat has been Chief Justice of the United States Supreme Court in your lifetime, all right? Pretty stunning. So given the lengthening lifespans and advances in medicine, a determined political party could actually maintain dominance of the Supreme Court almost forever. And here's why. Just to take an example of conservative Republican justices, but you could flip it around as well and make the same argument with regard to liberal Democrats if they ever gained ascendancy. So conservative Republican justices can strategically retire so that they retire when there's a Republican president that can replace them. And it used to be there were surprise nominations, people who were nominated by presidents and then their jurisprudence was somewhat different than expected. So examples of this would be Chief Justice Earl Warren and perhaps Justice White. But these days, presidents have learned to choose reliable ideologues and young, reliable ideologues at that. And then for me, really, the final straw is when the majority of Republicans in the Senate essentially said, we're not going to fill a seat that was vacated by the unexpected death of Justice Scalia, because President Obama, a Democrat, would be doing the nominating. So when you take out happenstance also as a potential means of changing a Supreme Court majority, that pretty much means that, for a foreseeable future, one party can pretty much control the court. So some of these sorts of effects can be ameliorated by having an 18-year staggered terms of office for the justices. And an 18-year term is consistent with the length of time on average justices have served on the court since 1950. The average is about 19.4 years and probably increasing, but it's not dramatically different. For 18 years, it's not dramatically different from that. And if a justice died or otherwise had to resign during their term, the replacement justice would be appointed to complete that term of office. So they wouldn't get another 18 years, they'd get the remaining time in the term of the justice they're replacing. Justices would be eligible for reappointment, though presumably few justices would actually be appointed to full 18-year terms, because even the longest serving justice in history, Justice Douglas, only served for 36 years, which is just barely enough to be two 18-year terms. So what are the benefits of doing this? This would actually preclude the Supreme Court from going long periods of time without new justices, and newly appointed justices will more likely reflect the evolution of the public's views. And the staggered terms would ensure that the ideological balance on the court could gradually change to reflect ideological changes in the electorate. Secondly, it would ensure the presidents had the same number of nominations during one presidential term, leaving aside the possibility that a president might also have to fill vacancies with a replacement to someone to serve an unexpired term. But leaving that aside, all presidents would have simply two nominations during their term. Unlike now, where you have Jimmy Carter, who didn't appoint any Supreme Court justices, and President Trump, who's already appointed two, or is on the path to appointing two. Let me not prejudge the issue. And might well get a third, depending on whether Justice Thomas decides to strategically retire next year. Third, these 18-year terms would lower the stakes for each appointment. So instead of appointing someone for 30 plus years and that person being able to strategically retire to keep the seat in the same party, you'd only have an appointment for 18 years, thereby lessening the stakes and presumably giving the possibility of lessening the amount of controversy attendant each nomination. And as a side benefit, this might actually leave a cadre of justices who could be substituted for justices who have to recuse themselves. Because now justices tend not to recuse themselves, even though if they were on other courts, they probably would, because they don't want to leave the court short, and it might result in an evenly divided court. So I want to talk a little bit about the state perspective on some of these things. So from the state perspective, many states have mandatory retirement ages and set terms for justices on their courts of last resort. So as of 2010, admittedly a little while ago, 32 states had mandatory retirement ages for their Supreme Court justices, generally between 70 and 75 years old. Although in Vermont it's 90, and it's like, what's the point? Okay, only 3 states give judges life tenure. Most of them have some sort of terms that vary from 14 years is the longest I've seen, till 6 years. All right, so what are the problems with this proposal? And there are probably many, but at least 2 that I will mention, and we can talk about some others potentially, is first, it's going to require a constitutional amendment, which is a virtually insurmountable hurdle. Very few amendments are adopted. And there might be a point at which the Democrats and Republicans get tired of the conflict, the situation we're in right now, but I'm not sure they're there yet. Second, the transition period will be difficult because in the short term, it will probably have the effect of entrenching a conservative Republican majority, which Democrats, of course, are not going to be thrilled about. But if the amendment were, let's say, to go into effect within a year or 2, the first 2, presumably the current justices' terms would end on the basis of seniority, which would mean that probably 2 of the first 3 justices to rotate off would be Democratic appointments. And if Justice Thomas strategically retired, it could be the first 2 justices to rotate off would be liberal Democratic appointments. So as I say, there may be other problems with this, which we might cover in questioning. But let me move on to a second idea, which is mandating partisan balance, particularly the Supreme Court. And there is actually an informal custom of doing that with respect to the New Jersey Supreme Court, and at least until Chris Christie, worked pretty well from 1947, again, until the Christie administration, and hopefully the state will actually get back on track with regard to that custom. On the national level, many agencies are actually headed by commissions that explicitly require partisan political balance. So Federal Communications Commission, SEC, FTC, the Federal Reserve Board. Right? And this is an artifact, these requirements are an artifact of a time when regulation was viewed as a science in which there were correct answers, rather than politics, which necessarily involves weighing conflicting underlying values about which people disagree. In effect, political elites and judicial elites believed that there were value-free regulatory decisions to be made. So I'll quote from a famous 1935 Supreme Court opinion about the Federal Trade Commission, where the court said the following about the commission. The commission is to be impartial, and it must, from the very nature of its duties, act with entire impartiality. It is charged with the enforcement of no policy except the policy of the law. Its duties are neither political nor executive, but predominantly quasi-judicial and quasi-legislative. Its members are called upon to exercise the trained judgment of a body of experts appointed by law and informed by experience. So what's been the experience with regard to these multi-member agencies? The latest research shows that the requirement of partisan balance does provide some constraint on presidential nominations. So presidents are often nominating people with whom they disagree with ideologically. So in that sense, it's worked, and that constraint has actually increased over time as the parties have become more cohesive internally, ideologically, and more distinct from each other. But, this partisan balance has certainly not brought consensual decision-making to these bodies like the FCC or the SCC. And moreover, the appointments process to such commissions has also broken down to the same hyperpartisanship that's affected the Supreme Court and other judicial nominations. And in fact, it's resulted sometimes in agency paralysis because they can't even get enough members appointed to form a quorum. All right, so in addition to those, that cautionary tale from government commissions and boards, the weakness of requiring partisan balance on Supreme Court would be that first it would insulate a party that loses elections over a long period of time from losing influence on the Supreme Court. It's not clear that's a good thing, that a political party that's out of touch over a long time with a majority of the country should continue to have that level of people on the Supreme Court. And secondly, it might actually validate the attitude that the court is just another forum for normal politics. And it might even lead to the justices thinking of themselves along those same lines, which would not be a positive development. Okay, so what about merit selection of judges on the federal level? And this would involve essentially the panel probably of lawyers and non-lawyers sorting through potential appointees and producing a list of a few names from which the president could choose. And we've actually tried this in the post-World War II era. So you did so well on the first question. Let me ask you this question. Guess which president tried merit selection for both federal courts of appeals judges and district court judges? Anyone have a guess? Very good. Did you know it, or you just guessing?
No, I just stayed because that was the way he operated.
I'm sorry, that was?
That was the way he operated.
Yes, absolutely. So, absolutely right, Jimmy Carter. And his goals were twofold. He wanted to select judges on merit, or as he said, all federal judges should be appointed strictly on the basis of merit without any consideration of political aspects or influence. And two, he wanted to increase the racial, ethnic, and gender diversity on the federal bench. So what were the results? Well, the quality of the candidates seemed to be better, although it's a little bit hard to judge that. At least that was the perception of the membership of the merit selection committees, which, granted, would be biased. I mean, obviously, they think they did a good job. But there is also some objective evidence. At least the district judges selected by these nominating committees received higher ABA ratings than judges that had been, district judges that had been appointed in prior administrations. And the process did absolutely encourage people who were not politically active, who were not affiliated with home state senators, to apply for judicial positions and be selected, and weeded out some of the weaker candidates. But the selections were overwhelmingly Democratic, and only 16% of the Court of Appeals nominees were Republican. And this reflected the composition of the nominating commissions that were heavily populated by those with Democratic leanings. So even in this era of less partisanship than now, and kind of an outsider president, or at least someone not as tied to the Democratic establishment as some other presidents, there was still, the results were still ideologically biased, although more could have been done to encourage greater ideological balance on the merit selection panels themselves, and that might have led to a different result. Now, again, with regard to the state level, because I'm trying to look at the state level as well, a lot of states have partisan or nonpartisan elections for state Supreme Court seats. And we can certainly talk about the problems of that form of selection and the benefits in the question and answer session if anyone wishes. But I want to focus more on the states that use something called the Missouri Plan. And essentially that's merit selection followed by retention elections. So these states generally have judicial nominating committees which forward a list of potential names to the governor. In virtually all of those states, the governor is limited to selecting names, selecting from the names presented, although in one state the governor can tell the committee, go back and give me a whole new second list of names. Generally, the initial gubernatorial appointment is followed up by retention elections, which are generally up or down votes on the justice without an opponent. And the initial period before retention election is generally something between at least 1 year and at least 3 years. And I say at least 1 year, at least 3 years, because generally these retention elections are held at the next general election following the minimum period. So if the minimum period is 1 year, it's 1 year plus the time to the next general election. However, in at least one state, New York, which is not technically a Missouri Plan state, there's the same merit selection, gubernatorial appointment, and then the judge just gets a 10-year term period. Right? So retention elections themselves can be problems, and they can raise something called the crocodile in the bathtub problem. Right? And you may ask, what is the crocodile in the bathroom problem? Right? So there's a, and now deceased California appeals judge who said that, deciding a controversial case when you know you're going to be facing election is like going to the bathroom to shave in the morning and finding a crocodile in your bathtub. All right? And he says your attitude is, hey, you know it's there. You try not to think about it, but it's hard to think about much else while you're shaving. All right? So that's going to kind of impact the way you decide cases. Or in one case, I think the Arkansas Supreme Court, they managed to avoid deciding whether there was a due process right to same-sex marriage for 2 or 3 years because they didn't want to do it before a retention election. All right. So generally, if there's a nominating committee from which which produces a list from which the governor selects someone, there's generally no need for confirmation by the state senate. So actually, Maryland also requires confirmation by the state senate, but most states don't require that. On the federal level, Senate confirmation could be substituted for a retention election. And there's a variation in the number of names that are forwarded by these merit selection committees, which is important because the shorter the list, the more restriction there is on gubernatorial choice. So one state only requires 2 names at a minimum. Many specify either 3 names or at least 3. Some specify a range, generally somewhere between 2 and 6. And generally these committees have as few as 7 members or as many as 17. And often they will specify the number of lawyers and non-lawyers. Most of them specify that the number of non-lawyers and lawyers be pretty closely divided, or pretty evenly divided. But the ones that don't will generally have more lawyers than non-lawyers. All right, so the weakness of this approach is, again, it would require a constitutional amendment, and moreover, it would put significant power over judicial appointments in the hands of those who aren't really politically accountable. Coming up with these names would involve making contestable value judgments that really simply can't be made in a neutral manner. They will inevitably be colored by some value judgments. All right. So ultimately, if we are so divided that we can't agree on science, logic, or even just plain facts, all right, and everything is driven by a polarizing clash of values, no method of selection will remove the ugliness and the political feuding from the process of appointing federal judges. So we can perhaps ameliorate some of the worst aspects of this hyperpartisanship by some of the proposals that I've outlined, or some of the ones that you may come up with during the question and answer period. All right, but ultimately, the fault, dear Brutus, lies neither in our stars nor in our processes, but in ourselves. Thank you.
So, I have a show and tell. That. Great.
That goes forward.
And how do I know what I'm going to have to
walk here
Okay.
for you. Just don't point it at me. Don't point it at the speaker.
Right. Yeah, you just told me not to point it at the speaker. Okay. So, I should begin just by apologizing for being late. I actually did time my drive, so I'd be here at 6:15. And I had this wonderful vision of being alone in the auditorium, waiting for everyone else to show up. And then my GPS told me that there was an accident on the New Jersey Turnpike. And I thought, well, that can't be too bad. And indeed it was. And on top of everything else, being in the car, driving here, I had the distinct displeasure of being riveted by the hearing today, the Kavanaugh hearing today, until finally I just couldn't stand it anymore, and I switched to a podcast under a theology of disability, which was much more productive, right? But that photo is not from today. That photo is from the first set of hearings for Kavanaugh. And when I put this little presentation together, I didn't really realize how perfectly timed it would be. But this might as well have been today, because if you put the whole process together, not just what happened a few days ago, but what happened today, and in some sense what's been happening over the past few years, you will be forgiven if this is your reaction. I'm going to be a bit more blunt than Bernie. We're living in a truly topsy-turvy world. It's not good, and part of what I'm going to try to do is actually convince you how bad our situation is. It's really that bad. It really is. And the reason it's that bad is that the system that we've developed, not just for judicial appointments, but for a whole bunch of institutions and processes in our form of government, and this is the only word that I've come up with, they're truly bizarre. And they're bizarre not just by some sort of theoretical absolute standards. They're bizarre by what, for want of a better expression, are the best practices of our peer countries, right? You've heard that about our medical system, right? Everyone else seems to be able to do it, seems to be able to provide health care more effectively, more efficiently, and more cheaply than we can. And it's not all that different with respect to some of the institutions and processes of government that we have. So my talk is going to overlap a bit with Bernie's. I'm going to focus a little bit less on solutions. Because again, my goal is just to convince you how bad it is. So let's begin with federal judicial selection. I'm going to be talking about some other things as well. So this is not quite the current Supreme Court. This was the Supreme Court before Justice Kennedy retired. And this is the process, the current process for appointing justices, right? In a way, the Constitution was written by brilliant people, but what they gave us in at least some respects was not an optimal system. And there are reasons for that. So the judicial power is vested in the Supreme Court and in inferior courts, and the judges of both courts have lifetime tenure unless they really, really screw up and get impeached and removed. That's that first block paragraph. And the second is in some ways the more relevant one. The president shall nominate and bind with the advice and consent of the Senate, shall appoint ambassadors, judges of the Supreme Court, and all other officers of the United States. So there are two pieces to that, right? One is a presidential appointment, which the framers, to a large extent, took from the Brits, right? The idea that judges were in fact agents of the crown in many respects and were appointed by the executive. But as with other things, and you can call me an Anglophile if you like, it's not something I'm embarrassed about. As in other respects, the Brits have moved on, right? And we haven't quite. The piece that the framers added was Senate confirmation, right? So the president would not have exclusive authority to appoint judges. The Senate would have to confirm, which in principle, right, in principle sounds like a great idea. It's a way to check what might be the excessive arbitrariness of presidential appointments. And it seems to me that for a good deal of our history, it sort of worked that way, at least as a sort of theoretical backstop. In recent years, as we've seen in this nomination battle, as we've seen in some other nomination battles, in recent years, the opportunity that the Senate has to give its, quote, advice and consent has simply become another opportunity for political theater. And for the politicization of the process. We would almost be better off, not with the current president, I'm not sure I really want to say this, but we'd almost be better off simply having a system of presidential appointments without that additional layer of theater. Almost. Let me not commit myself to that. But certainly this combination that has been bequeathed to us was a recipe for trouble. Fortunately, it actually took a while for that trouble to assert itself. So Bernie and I actually both clerked on the Supreme Court, right, in 1982, 83. That's the court that those are the justices that were there when we clerked. I clerked for Justice Brennan. That's me, right? Right. I was just slightly younger then, right? I was just slightly younger then. Right. Which one? And Justice Brennan, who was known as the great liberal lion of the court, was appointed by President Eisenhower. It's often theorized that Eisenhower didn't really know what he was getting into. That's part of it. Eisenhower was really more interested in sort of filling the Catholic seat, what was then considered to be the Catholic seat on the court, than in a particular ideology. But maybe that's the larger point. He wasn't all that interested in a particular ideology. And though he was said to have joked that appointing Warren and Brennan were the two biggest mistakes of his presidency, that was a joke, right? That was a joke. Presidents realized that they appointed the people they did, and then folks evolved, right? Folks evolved. That was seen as simply part of the natural process of what happens when folks get appointed to the Supreme Court. Justice Brennan was not notorious as a liberal, as a sort of great liberal when he was on the New Jersey Supreme Court. He hadn't been on for very long, but that wasn't his reputation. His main reputation was as an innovator in the reform of judicial administration, about as boring as you can get. When he got the phone call to meet with the Attorney General in Washington, this is a true story, he was sure that the Attorney General was forming some sort of national commission on judicial efficiency, just sort of. And he thought he was going to be asked to be on this commission because he had done such a great job in New Jersey. And he shows up in Washington, and the Attorney General says, the President wants to speak with you. And Brennan thought, why is the President interested in judicial efficiency? So it was just a different time, right? It was just a totally different time. Byron White, right, who, when I clerked, was considered sort of on the right wing of the court. I mean, not in the current sense, but on, more conservative than liberal. He was appointed by President Kennedy. John Paul Stevens, who, when we clerked, was sort of fairly in the middle, moved considerably to the left ideologically over time. He was appointed by President Ford. Sandra Day O'Connor had just been recently appointed, and she was a bit of a mystery. Right? How she would turn out was not entirely predictable, and we were all sort of guessing about how she would resolve particular sorts of questions. I should add, Justice Brennan was replaced eventually by Justice Souter, appointed by President Ford. And Souter was probably the last justice who actually surprised the president who appointed him. When he was appointed, the word was that he was a sort of reliable Republican, conservative jurist, and that's not how he turned out. And to my mind, that's a great thing. Not that he moved in one direction or the other, that he evolved in office. To the politicians who make these decisions, he was the sort of the example of what they needed to avoid in the future, and why they needed to be much, much more careful and methodical about the appointment process. So he was probably, I think, the last justice who sort of literally changed, surprised. Not just surprised the president who appointed him, surprised the rest of us, grew, right? Grew, evolved. And that's a very sad thing, right? People in these lifetime offices should evolve. And I frankly am not, don't necessarily care in which direction, but they should evolve. So this is a graphic illustration of that. So this is in 1982-83. The blue justices were appointed by Democrats. The red justices were appointed by Republicans. And you should take this order with a grain of salt, but it's based on some social scientists who come up with sort of indexes of ideology. And there's no question there's an ideological element to law, right? There's a political element to law. That's inevitable. But does that mean that it's inevitable that there's a partisan element to law? Right? Those aren't the same thing. A partisan is about political parties. It's about political tribalism. It's not just about the philosophy somebody has. It's about the allegiances somebody has. Kavanaugh today, whatever you think of the particular allegation, he did himself and the court and the judiciary no service by attacking the people who opposed him as part of a left-wing conspiracy. He said that that this was the old Clintonites who were just taking revenge on the fact that he worked for Ken Starr. He was casting it not just in ideological terms, but in tribal terms. Now, I should say, one of the things I teach is American Indian law. There's nothing wrong with tribes. There's nothing wrong with Indian tribes. There's a lot wrong with the sort of, if you can come up with a better word, I'll take it, but there's something deeply wrong with the sort of tribalism that we've descended into. That's a bigger issue, right? A political tribalism and polarization is a bigger issue. What I'm concerned about is how it's infected areas that should be at least tiny little refuges from that tribal. So if you look at this list, the upper part of the list, they were all appointed by Republicans, and they were relatively liberal. And Byron White, appointed by John Kennedy, is in the middle. So the only one who really is sort of reliably aligned with the party that appointed him is Thurgood Marshall, right? 1 out of 9. If you go back in time, it was even more mixed up, right? This is in '62. So you had two Democrats who were the most liberal, two Republicans who were the most conservative, and a lot of mix-up in between, which is as it should be, right? Because justices should grow, and the appointment process, however political, should not be so scientifically calibrated that it produces predictable results. This is the sort of mix that you want, right? At least as long as you're going to have political appointments to begin with. Even in 2002, 2003, right? The most liberal justice at that point was John Paul Stevens, appointed by President Ford. And then you had Ginsburg and Breyer, who were predictably liberal, but there was David Souter in between. By the time you get to 2017-18, though, the alignment between party on the one hand and ideology on the other becomes much, much more rigid. And in a way, this understates it, because this is not just a range. There's a real gap. There's a real gap between the blocs on the court. So for the past few years, we've really had a liberal bloc, well identified, not in every single case, fortunately, but in many cases, and a conservative bloc, and then we had Anthony Kennedy as the so-called swing justice, and that's, of course, the seat that Kavanaugh is supposed to be filling.
Have you gone through this stuff? Have you seen the separation getting bigger?
Oh yeah, no, absolutely. So, again, I'm not the expert on this because I'm a law professor, not a social scientist. But this is what the social scientists point out. So the higher the bar, right, the more variation there is among the justices appointed by a particular party. right? So in the period from 86 to 93, among Democratic appointees and Republican appointees, there was a lot of variation, right? Again, the higher the bar, the more variation among the justices appointed by the same party. By the time you get to the 94-2004 period, the Democratic variation actually gets reduced. That's partly because there were fewer Democratic appointees. And then by the time you get to 2010, 2014, they're both predictable, right? Again, the lower the bar, the more predictably aligned the justice is with the ideology of a particular party. And that's unfortunate. That's unfortunate. The other thing that's been happening, and Bernie talked about this a little bit, is the nature of the confirmation hearings. There were no confirmation hearings until Louis Brandeis in 1916. And the reason that some senators demanded a hearing, quite frankly, was because he was the first Jew appointed to the Supreme Court. So of course there had to be a hearing, but he didn't show up. He didn't show up. I mean, and he wasn't expected to show up. The first justice who actually did testify at his own confirmation hearings was Felix Frankfurter, who, guess what, was also Jewish. There's a pattern developing here, right? Frankfurter began the pattern of being willing to answer questions, but not being very substantive, which is, at least to my mind, appropriate. Potter Stewart, there was a little heat when Justice Brennan was appointed, not that much. When Potter Stewart was appointed, he sort of got it from both ends. There were Democrats who were worried about his views on civil rights, and the Republicans who were worried about his views on national security. But still, it wasn't all that contentious. Then we come to Robert Bork. Some of you might remember the Bork hearings, which at least were about ideas. And Bork was probably the last nominee to be honest about his ideas, to his credit. But the result was this incredibly divisive hearing. Then you have Clarence Thomas, with the accusation of sexual harassment, and then Chief Justice Roberts, who coined the metaphor that he was merely an umpire calling balls and strikes, which to my mind actually is a proper aspiration for a judge. Where he went wrong is in not being willing to admit that it's only an aspiration, right? No, I'm serious there. It's tough to convince people that yes, law is inevitably political, but we should aspire to make it as unpolitical as we can. And certainly what we can do realistically is make it less partisan than it is. So I'm not going to repeat what Bernie said about state judicial selections. There actually are a fair number of states where there are commissions that are involved, although it's still the governor who has the final say. But I do want to talk a little bit about what convinces me more than anything, at least to my mind, that our system is deeply dysfunctional and bizarre and not inevitable, right? Not inevitable. It's not just something we have to live with. And that is, just as in medical care, there is a world standard. There's a world standard and we don't meet it. We're not part of the Commonwealth, right? The Commonwealth are the countries that were associated in one way or another with the British Empire, even though most of them are now independent. We gained our independence way too early to become part of the Commonwealth. The Commonwealth is a bunch of independent countries, but they do get together, and they do have bureaucrats who write reports. And there's this report that they wrote on best practices for appointing judges. And I just want to give you one little piece of it. I mean, it sort of makes you cry, right? Because this is what they actually try to do. Judicial appointments should be made on the basis of clearly defined criteria by a publicly declared process. And they take that notion, in many countries, they take that notion of a publicly declared process very seriously. When there's a vacancy, they put an ad in the newspaper. It's a job, right? People apply, and then there's a process for going through the resumes. And then the process, so it should be made most clearly on the basis of merit, right? On the basis of merit, although what's been worrying them recently is making sure that in thinking about merit, you also take into account the need for a diversity. So, so that's a real question. But it's a real question in admitting students, it's a real question in hiring faculty. It's the sort of question any hiring process has to think about. But the important thing is this idea of appointment on merit, right? That is the goal. That is the goal, to really pick the best person. So the Supreme Court of the United Kingdom, it's a fairly powerful court, not quite as powerful as the Supreme Court of the United States, but it's a fairly powerful court. It has 12 members. It does have more turnover than our court because they do have a mandatory retirement age. But just recently, 3 new justices were appointed, and there they are. You probably haven't heard of them. That's okay. Here's the official announcement. Her Majesty the Queen made each of the appointments on the advice of the Prime Minister and Lord Chancellor, following the recommendations of an independent selection commission. The Brits use language in a slightly different way than we do, right? When they say on the advice of the Prime Minister and the Lord Chancellor, what they mean is on the order of the, right? It's sort of impolite to say the Queen takes orders, but she does, right? She doesn't, right? So when they call it advice, they know what they mean. And in fact, even the Prime Minister and the Lord Chancellor play almost zero role in the actual selection. It's these judicial appointments commissions that actually do the work. And the judicial appointments commissions are made up of senior judges, some well-respected lawyers, and a couple of lay people thrown in the mix. No politicians. No politicians. And it's not, and they don't bother with this idea of, giving 2 or 3 names, right? They say who should be appointed, right? Who should be appointed. There are judicial appointments commissions for the various divisions of the United Kingdom, Scotland, England and Wales, Northern Ireland, and then they combine the process when they appoint Supreme Court justices. And these 3 folks got appointed, no controversy, no fuss. I mean, it's almost remarkable. It's not to say the process is perfect. It certainly isn't. No one would claim that it is. They're constantly sort of tweaking it, criticizing it, but it works. And even in countries that don't have these sorts of commissions, there are powerful conventions that guide judicial appointments. So the Prime Minister of Canada has a lot of power to appoint justices of the Canadian Supreme Court. A lot of theoretical power. And there is some politics. There's no getting around that. But there are also sort of very ingrained practices about who qualifies and who doesn't. And if you've gone up the ranks of the Canadian judiciary and you've done a good job and you're recognized by your peers and by the legal community as having done a good job, that's the best ticket to get to the Canadian Supreme Court, even though the appointment is theoretically political. So some countries in the Commonwealth use a more political system. Some countries have these commissions, but they all have this aspiration. Even Hong Kong, which is not part of the Commonwealth, which is part of China, for heaven's sake, has a less political process for appointing judges than we do. And that's because of, oh, thank you. And that's because of the British tradition that they still, with a lot of difficulty, still try to live out. So I'm sort of running out on time, but I do just want to mention a couple of other things. What we lack is not just a good process for judicial appointments. I think more generally what we lack is a sense that certain institutions, like the courts, and certain processes need to be, at least as much as we can, immunized from partisan politics. And in a way even more outrageous than the way we pick judges is the way we referee the process of democracy itself, right? A democracy is supposed to be political, but democracy needs to be refereed. It needs to be done in a fair and reliable way. And the process by which we referee democracy is shot through and through with the partisan politics that should be the result of democracy. All right, so, it's the old problem, garbage in, garbage out, all right? So what do I mean by that? You've heard of these problems, right? You've heard of these problems. There's gerrymandering. In most states, the red ones, legislatures control the drawing of congressional districts. A few states have begun to enact reforms, but most states haven't gotten there yet. That's crazy, right? And I just want to impress on you how crazy that is. That's not the way the rest of the world does it. Other countries have legislative districts, and they have professionals who draw the lines. This is simply an illustration of how gerrymandering works, right? If you have 60% blue, 40% red, you can draw the lines in a sort of fair way, or you can jiggle around and without changing the number of people in each party in the population, you can pack people into certain districts so that the actual results are totally contrary to what democracy might require. So these are some of the more notorious examples of gerrymandered districts around the country. My state, Pennsylvania, its state Supreme Court had the courage to say that it's unconstitutional according to the state constitution. So we're actually on a slightly better trajectory. Another thing, who manages just the mechanics of elections in the United States? Right, secretaries of state. In most states, secretaries of state are elected officials. Again, that is nuts, right? That is totally crazy. I mean, it's not quite as crazy as something that Pennsylvania does, which is elect coroners. Right? That's even more crazy, right? As if being a Democrat or Republican would qualify you to examine bodies. But electing secretaries of state, the people who run the elections, is truly strange. One notorious example was in 2000, right, where you had the so-called butterfly ballot and hanging chads, and running the whole process, including running the recount, was the co-chair of the Bush for President campaign in Florida. And I have a whole quotation from her, which I will skip because I am running out of time. And finally, and this is probably too far to even suggest, the person who presides over the House of Representatives is the Speaker. We think of the Speaker as being, first of all, the head of his or her political party in the House of Representatives. We take that for granted. We've taken that for granted since Henry Clay was Speaker at the beginning of the 19th century. So Speaker Ryan, right? Speaker Ryan is both the presiding officer and the head of his party. And if you think about it, that's also truly odd, right? The presiding officer should be the person who makes sure that both sides are treated fairly. You can't even hope to do that if you also happen to be the head of one of the sides. And again, forgive my being an Anglophile. The Speaker of the House of Commons when he's elected or she's elected, resigns his or her party position, never again speaks politically. It is like a lifetime sentence, and is never challenged for re-election by the other party, because that person is seen as being outside politics. This is John Burkhardt, who's the current speaker, who's a very forceful personality, an incredibly forceful personality as to the procedures of the House, but not as to substantive politics. So why has our system of governance failed to produce and sustain professional, fair, nonpartisan processes? I have some thoughts, but I'll leave those to the question and answer period. Why have we fallen so far behind accepted global best practices? And is there anything we can do about it? I would consider some of Bernie's reforms. I have some thoughts of my own. But I think the first thing we need to do, again, and the health care analogy just sort of keeps coming back at me. The first thing we need to do is just realize how broken the system is. And it's only then that we can begin to try to reform it. There's just a final irony. If you look around for institutions that are relatively non-political, non-partisan, they're the ones that the framers of the Constitution probably least expected, right? We actually have some non-partisan professional institutions. They're located in the executive branch, which again, the framers would have been very confused by. But they sort of do their job pretty well. The FBI, right? People trust the FBI to be, not when J. Edgar Hoover was director, but the FBI has grown into a deeply trustworthy institution in most respects. And the Federal Reserve, which has enormous power to set interest rates, but does it in ways that meet the standards set by the profession, and will often disappoint and surprise the presidents who appoint them the way justices of the Supreme Court used to. And of course, who can forget, right? The person who might save us all. Okay. So thank you.
We're ready for our Q&A. Thank you. So we have, those of you who have questions, the microphone will come to you. Do your best to refrain from making long talks before, make sure you have a question at the end of it. So Ethan is going to come around with the microphone. Okay, we've got a couple over here, Ethan.
Thanks. Yeah, you mentioned that Robert Bork was I guess in the recent times, that his confirmation process kind of evolved into something different, or morphed into something very different. And part of that was because of his extreme views on constitutional law, but he also played a pivotal role in the Saturday Night Massacre, did he not? So it was essentially a question of whether or not we should be rewarding bad behavior.
Well, he was kind of a hero, as I recall, on the Saturday Night Massacre. Because, no, that's right. Oh, right, so, is this on? This isn't on. Oh, it is? Okay. Yeah, that's right. I'm misremembering. But I mean, I think the dilemma was that Elliot Richardson, who was the Attorney General, and Ruckelshaus, I think was the second in command at the Justice Department, had given testimony to the Senate during their confirmations, committing not to fire the special prosecutor. Bork had not, and Bork, I think, offered to resign. I mean, he was willing, my understanding is, to do that. But the problem was that Nixon would have just gone through the rest of the Justice Department, firing everyone until he got to someone who would fire Archibald Cox. And I don't think that would have served the Justice Department well. So I guess, I mean, I was a little young at the time, so, maybe this is naivete, but I don't fault him for that. I think he did what he needed to do to save the Justice Department, and what was going to happen eventually anyway, if not him, then someone else.
Right, so I don't recall those hearings in sort of in minute detail. My sense is that his role in the Saturday Night Massacre was a secondary issue. I mean, that's my sort of vague memory. And again, to be fair about it, it's partly, so his rationale for firing Cox was partly that if he said no, then everyone else would say no, and the whole Justice Department would collapse. That was one reason he gave. The other reason he gave is that Richardson and Ruckelshaus had made personal promises to the Senate, I guess, or to the Congress, that they would allow Cox to maintain his independence, and Bork had never made that personal pledge. So he didn't have that sort of same sense that he was violating his own honor by obeying a presidential directive. One thing that did happen in the Bork hearings was this argument that Bork was, quote, out of the mainstream, which he was in many ways. I mean, he had idiosyncratic views that by today's standard would probably not get him a Republican nomination. I mean, he was an arch conservative in some ways, but he also had sort of some interesting, quirky views on various things. And the argument was that he was simply out of the mainstream. And to my mind, whether or not I agree with Bork, and frankly, I don't, I mean, I should just put my cards on the table, I think that was a bad argument. There's nothing wrong with having out of the mainstream justices. I disagree with almost everything that Justice Thomas writes. I think he's one of the more interesting and provocative and actually valuable members of the court. And he's an important part of the conversation that the court has in its own deliberations. So the consequence of this claim that he was, quote, out of the mainstream, a claim that ultimately prevailed, is that every other nominee since then has endeavored, even against all the evidence, to argue that he or she is in the mainstream, or that it doesn't matter whether he or she is in the mainstream because he or she is simply calling balls and strikes. And the response to the whole Bork debacle was that we no longer even have the sort of intellectually interesting process that the Bork hearings represented. And that, I think, I mean, I don't think nominees should answer questions about particular views, but I think they can answer questions about their broad jurisprudential perspectives, and we no longer even have that, and that's a shame.
Both of you clerked quite a few years ago, but my understanding is that today at the Supreme Court, they still don't use email and they still do everything in longhand. And that would be, I think, a good reason why 18-year limits would be good. Is that still true, that they are so far behind? I mean, I guess my concern is that they really are out of touch with. We saw some of that, when the senators were grilling Zuckerberg and all those other tech titans. They're really clueless. And these days, there's a lot of issues that you really have to understand. And one of the, I think, general objections I have, because I came from the technology business, is how many bad decisions are made by judges about patent and intellectual law issues, and it shows just a complete lack of understanding.
Well, I mean, when we were clerking, the court was using computers. It wasn't exclusively writing out in longhand, so I would be a little skeptical of.
They send notes to each other.
Oh, okay. Well, I mean, they may do that. I guess I'm not bothered by that. I think a lot of the work probably does go on by computer. And, they're all in one building and they have personal contact, which I think is actually probably not a bad thing, particularly in terms of coming to consensus on issues. As far as patent cases, very few of them are expert in patent. I mean, there's a lot of areas of law that you should know something about if you've got the responsibility of the Supreme Court does, but there are a lot of areas where they're a little weak on and they don't handle them well. And I don't know if it's because they're not technologically savvy, although I suspect they are not particularly technologically savvy, but there's some areas of law that just don't come up all that often. And you talk to people in various discrete areas of the law, and they'll roll their eyes whenever the Supreme Court takes a case in their area because they know they're going to screw it up. But you can hear people who are experts in administrative law say the same thing about administrative law. So I wouldn't tie it to their lack of technological sophistication.
Yeah, so just this thought. Even if the justices were even if they were all 35 years old, they would still be generalists. They wouldn't, and to the extent that some of the issues that they face involve technological complexity, whether they're 35 or 85, they're not going to be expert. To the extent that it's helpful for them just to have a sense of the current culture, clerks are pretty good at conveying that. I don't know if they use email. One of the things that happened, one of the great things about clerking is, at least when we clerked there, is the Supreme Court police they memorize the faces of all the clerks. So you just go in, you go past security, they know exactly who you are. The day the clerkship ends, you might as well be dead to them. I was once showing some people around the building, and I sort of turned the wrong corner, and 5 armed guards came out of nowhere. And it would not have helped to say I used to be a clerk. I mean, that would not. So I don't know all the work practices. I suspect that if they don't use email, and I don't know whether or not they do, I suspect that they don't use email, it's actually for a very sophisticated reason. What do you suppose that is?
Could easily get hacked.
Yeah, they don't want to be hacked. We actually had a cutting-edge word processing system when we clerked, well before most folks were using word processors. But one of the things that the justices insisted on, and which I suspect they still insist on, is that it not be tied in to anything larger. So I don't know how they do their research these days, but my suspicion My guess is that the computers that they use for writing opinions are just physically separate from the computers they use for legal research, because legal research requires you to access the web. So if they don't use email, that might be one reason.
I'd like to point out the President used email last week.
All right. They also still have spittoons at their seats on the bench.
Just a quick comment. There's a great story about Justice Roberts, right? There's a recent case within the last maybe 3 or 4 years about cell phones and whether searching through a cell phone constitutes an unreasonable search. The counsel saying this is a violation of the 14th Amendment was arguing the case. And Justice Roberts all of a sudden got an idea and said, wait a minute, you mean they could search my cell phone without a warrant? Yes. Well, he got the message and, wrote either he or someone else wrote a pretty great opinion finding purpose.
That was just rhetoric, believe me.
Are you talking about the Section 5?
No.
The
gerrymandering.
Oh, okay. Oh.
This is to Mr. Dane, actually. When you were discussing how the Senate hearings have become, like you said, a theater, you mentioned that we might as well get rid of the Senate approval for the president's nominations. Don't you think this will upset the balance of power between the three branches and with all the checks and balances?
Yes, it would. So that wasn't a serious proposal. Again, ideally, I think, frankly, I think if we're going to amend the Constitution, which, as Bernie points out, is really hard and a really big deal, if we're going to amend it, I think we should go for broke, and we should leave both the president and the Senate out of it. I mean, that would be my suggestion, and develop some other system. It doesn't have to be the sort of system that the Brits have. It could, but we need to really rethink the process from scratch. So I was being facetious when I said leave the Senate out. If there was any seriousness in it, it was simply the thought that since at the end, is that the Senate, it seems to me, doesn't anymore act as a quality check in a way that it might have been envisioned to act. It acts as, if it's as we saw it with the Merrick Garland appointment, if it's run by the opposite party, it simply acts as an arbitrary break, totally arbitrary, totally unreasonable, perfectly constitutional, but totally unreasonable. And if it's the same party, then in most cases, who knows how this Kavanaugh business is going to end up. In most cases, the nominee gets confirmed, but only gets confirmed after a lot of angst and a lot of theater and a lot of resentment. That doesn't help. So I was being facetious, but not entirely.
Yes, I have the mic. I would like to ask each of you to comment on what role you think money in politics has contributed to the ultra-partisanship we see today.
Wow. Tough question. You want to go first? Or you want me to?
Okay, so there's a big piece to that, right? There's a big piece to that, and there's a smaller piece. The big piece is just the role of money in politics in general, and the way it's contributed to the sort of political tribalism that has developed. And that's a problem. That's a major problem. It seems to me that to the extent that a lot of the major sources of money tend to be at the political poles rather than in the political middle, that simply gives folks, along with other things like gerrymandering, it simply gives folks an incentive to gravitate to the edges of the political spectrum rather than the middle. I should say though that though I'm very interested in that, that's not my expertise, right? I spent a week this summer at the Chautauqua Institution in New York, which is a wonderful place. Sort of like this, right? Sort of like this. You learn a lot. You hear interesting conversations, and the major theme the week I was there was polarization and how to overcome it. And I didn't have much to contribute. I had a lot to learn. I had a lot to learn from people who were talking about how things like the role of money can be overcome by grassroots activism, and by less political grassroots activism. People getting together in small towns across the political divide to welcome refugees. It's remarkable how in the middle of red states, you have these sort of incredibly welcoming communities that you wouldn't expect if you were simply looking at the political slogans. But again, that's not my expertise. With respect to what we were talking about, with respect to judicial selection, I'll just say two things. First, the idea of running advertisements, for heaven's sake, for and against judicial nominees, that just piling one craziness on top of another, and obviously somebody has to pay for those ads. And there's a similar, in some ways worse problem at the state level when you have elected judges, right? It used to be in states that had elected judges, sure, the judges would have to campaign, right? So they would go to 10 or 20 or 100 of their friends, and they would get little contributions, and they would run a campaign. Now in some states, these campaigns are financed by the same partisan mega money forces that we see in gubernatorial and senatorial and presidential campaigns. Right? Sometimes with cases before the judges, which is corrupt. Sometimes without cases before the judges, but just people who have an ideological axe to grind, often from outside the state. And states that my inclination is to think that electing judges is a really terrible idea, but it actually worked in some states. And it worked in some states because there was a tradition of relatively nonpartisan sort of consensual elections. Wisconsin was famous for that, right? In Wisconsin, sure, judges were elected, but very good people got elected because that's the culture that the process created. When you start getting these outside forces in spending money, the last I heard, the judges in Wisconsin were literally throwing things at each other. I mean, it's not good. So I agree with you, that's a problem.
I would say that in general, campaign finance is a big problem with our system. I'm not sure it contributes, it's one of the major contributors to polarization. And in some ways, ironically, it actually may reduce polarization because interest groups, certainly business interest groups, have interests in cultivating both Republicans and Democrats. So in some ways, that is actually a unifying feature with regard to some issues. I don't think that unifying feature is worth the problems of campaign finance, but there's an irony for you. It might actually ameliorate the polarization a little bit in some respects. I think the bigger problems with regard to polarization are the drawing of legislative districts, which cause people to, the people who are elected to be extreme. The money is definitely a major problem in state elections. I mean, the state judicial elections now are awash in money. And often, I was just reading about this this morning, often, more than you'd expect, the parties that are contributing to campaigns are also parties to litigation before the judge, and it's hard to believe that that doesn't affect judges in some way. And if you want to see an eye-opening case, there's a Supreme Court case called Caperton versus A.T. Massey Cole, and it's about a West Virginia judicial election where I think over 50% of the funds was given by a company that had already lost a case in the trial court, was on their way to the Supreme Court, and they essentially pretty much fully funded the campaign of someone who would oust a judge that would be unsympathetic to them. And in fact, that was so bad, a majority of the Supreme Court said that's a violation of due process.
Could I ask one further? What do you think of the idea that money should be treated like votes, and one could only contribute to a campaign in which one could vote?
Okay. So two different. I would not equate money and votes, because it was one person, one vote, and money is not distributed equally. But I take it that you mean, should there be a limitation on outside funding? So should the only people who contribute be people within the constituency?
That is buying the election and denying the vote, the influence of the actual vote.
I think there's some states that limit outside contributions. I guess I'd be uncomfortable with completely eliminating the possibility of outside contributions. We do have
Indirect, yes, but directly to a candidate's campaign. You could do it to parties, you could do it to committees that pushing for environment or whatever issue.
But for instance, let's say, a few years ago, you really strongly believe in gay marriage, and there's certain representatives who are not your representatives that you want to see at least having a chance in an election in their own district. I don't see a theoretical problem with contributing money to that candidate. So I think we are interrelated enough that even people who aren't your representative can still represent some of your interests. So I would be hesitant to make an absolute ban. I do think there is an issue sometimes with the amount of outside funding, which then can tend to overwhelm.
I'm not saying that you couldn't contribute to an interest. So in other words, if you couldn't maybe contribute directly to a candidate, but you could contribute to an interest group that was pushing for gay rights. That would not be
I understand, and worth considering. I guess I would be nervous for the reasons that I indicated.
I agree.
Thank you.
Thank you for your presentation. I have a question. It's me. What does the term settled law mean, and when is a law settled, if you will?
On the Supreme Court, it is really not a constraint on Supreme Court justices. It is a matter of discretion, and in some ways it has to be. I mean, there are certainly precedents that are out of date or really wrongly decided, and you don't really want to pass Supreme Court to absolutely bind a future Supreme Court. So it's really up to the discretion of Supreme Court justices. But here's an idea just to throw out. One way we might deal with some of these problems is to say, if someone is suggesting the Supreme Court take a case to overturn a precedent, the court should only be able to grant that case if 6 justices agree to hear that case to overturn the precedent. So that now creates a situation where you can't just have a bare majority that's willing to overrule a precedent, that you need a bit more than that, and presumably would encompass more than just one ideological wing of the court. I just throw that out as kind of an interesting suggestion to think about. Might be a little hard to administer and figure out exactly when someone is arguing to overturn a precedent or not. But that might be one way to give settled law some bite in the Supreme Court context.
So I actually think that the idea of settled law does have a legal meaning, because our system of law relies so strongly on precedents, and even the Supreme Court should feel bound most of the time by those precedents, but not absolutely, and there are often good reasons for overruling a precedent, sometimes because the attitudes that produced a precedent in the first place no longer seem to be compelling, sometimes because the precedent itself has sort of collapsed of its own weight, right? It sort of created new legal problems of a sort that revealed that there was something rotten at the core of the precedent to begin with. So I think there is a process of reasoning. It's not just discretion. I think there's a process of reasoning that judges can and should go through in thinking about precedents. Your question, though, I think has a slightly different sort of valence to it, which is the use of that term in these silly confirmation hearings, because the way the term settled law is used is as an ambiguous code, right? It's a way of trying to reassure the senators who support a precedent that you're not going to just casually overrule it. But it's also a way of avoiding the question of what you personally think of the precedent, right? So if you notice, and that's nothing wrong with that, but that's the way the game is played. So you'll notice when Kavanaugh, and he wasn't the first one, is asked, would you consider overruling Roe v. Wade? His answer is, well, it's settled law, right? And again, that sends two different messages to two different groups, right? To the people who are very, very afraid of Roe v. Wade being overruled, the message is, I take it seriously as a precedent. To the people who desperately want to overrule Roe v. Wade, the message is, sure, it's settled law. Lots of cases are settled law before they're overruled, right? And I'm using that, and I, the nominee, am using that language to avoid saying anything else. So yes, I think settled law is a very important idea in the law. I think it's also part of the theatrics of these nomination hearings.
Quick question about the virtues of surprise in a justice. Can you talk a little bit more about that, especially in light of what I take it are some of the admirable qualities of sort of technocrats and, you know, more meritocratic system where we wouldn't necessarily want surprise. So when is surprise good in a justice?
There you go. When is surprise good? I mean, the flippant answer is surprise is good when the surprise is a movement toward the side you like. It's bad when it's movement in the opposite direction. I think evolution, I think being open to new ideas, I think being skeptical of one's own position is a good thing in every justice. And I think if you have that, you will evolve on certain issues. And I think what's critically important is that the judge really have a somewhat open mind, where at least, you know, you have a chance of convincing that judge that your position on the law or your position in a particular case is correct. And, you know, if you have, let's not be too greedy, let's say 7 justices that are, or 5 justices that have that attitude, you know, they're going to do some unexpected things in various directions. So, you know, I don't know that you need change on the level of a Justice Blackmun or a Justice Stevens, much as I admire those 2 justices. But, you know, I mean, Justice Kennedy, I mean, for all the kind of beating up he gets by conservatives, I think in general he has stayed fairly true to conservatism, but he's had an open mind on things. He's had an open mind on gay rights. And it's very interesting to see, because as soon as Lawrence versus Texas came out, which was the Texas sodomy law, you knew that he had to come out and say that there was a due process right or an equal protection right to gay marriage. I just don't think there was any stopping point in between there. But it was interesting to see him kind of convince himself that that's where he had to be. So, you know, I guess I'm not one of these people who thinks great surprise is a good thing in itself, but small surprises signify an attitude of mind that I think is very important.
So I think surprise is important, actually is important and is valuable, but in different ways. From the point of view of the president, if we're going to have presidents appoint justices, we should have presidents take the attitude that they should be willing to be surprised by the justices they appoint, which is not even to say that the justices themselves will, quote, evolve, but that the president should not try to fine-tune the process so minutely that they can be assured of a certain set of outcomes, which is the system that we've evolved into. And why is that important? Because if essentially the process of appointing judges is fine-tuned and micromanaged and predictable that way, we might as well just skip the middle step and not have the courts decide these questions, right? We might as well just have them decided politically to begin with. So surprise, I think, is important at that level. At the level of the individual justice, the potential for surprise and the potential for surprising yourself, which is what sometimes happens, is the sign of an open mind, which is important to a judge. And it's also the sign of somebody who understands that the experience of being a judge can itself, and the experience of being a Supreme Court justice in particular, can itself shape you, right? When President Roosevelt appointed Justice Frankfurter, he appointed him because Frankfurter was a reliable political liberal. Right? He had been on the Harvard Law School faculty. He was well known as a defender of the New Deal, a great political liberal. He turned out to be, in many ways, again, not by current standards, but by the standards of the day, he ended up being one of the more conservative justices on the court, because having been appointed a justice, he suddenly realized it's a different role. He was no longer on the Harvard Law School. Well, he still thought he was in the Harvard Law School faculty. That's a different problem, because he was just incredibly obnoxious. That's a whole separate issue. But he realized that the role of a judge is just different. Now, I happen to think that a lot of his opinions are nonsense. But for better or worse, they grew out of his sense that he was playing a radically different role than the one that got him noticed in the first place. And that's much harder these days.
We're starting to get close to the end. Would you raise your hands, those of you that still have questions? Because we want to get as many of you, your questions answered. Okay, so 1, 2. Anybody else? 1. I see 2. Yeah, 1. Oh, 2, 3. Okay. We have 4 more questions, and then we'll call it a night.
What is your, I probably know your view already, but what is your view of the Supreme Court's decision to allow corporations to be considered as people and be able to contribute as much money as without showing any record of who they're contributing to, and Obama even said that was a terrible decision. So I just wondered what you think about that. I'm sorry, I should know the name of this case. It's a very famous case.
Citizens United.
I don't think there's a First Amendment right of corporations to pay for unlimited campaign speech. So I guess I disagree with the opinion, although I can see the intellectual foundations of it, but I just don't. I don't agree with it, and I can't say I'm an expert on that, but that's just my inclination. I'm sorry, what? I assume that it's not likely to be overturned in the near future, but sometimes these things take time. Plessy versus Ferguson was the law for 50-some years, so sometimes it takes time. But I would not. Well, first of all, I don't think the court likes to really reverse very recent precedents. Anyway, particularly when it gives the appearance that it's reversing it because of a change in the political composition of the court. But I don't see that Citizens United being overturned at any time soon.
I should just, without getting into Citizens United in any details, it's just one little irony here. The view that political contributions, that there's a free speech stake in political contributions, was originally pushed by the liberals on the court, or at least some of the liberals on the court, especially my old boss. So, as with many things, the paths of judicial doctrine are not always obvious, and it's sort of it's a case study in how legal views and political views don't and shouldn't match up in a way that we sometimes assume that they do or should.
Just a side note,
today the word bork was used as a verb in the hearings. They said, one of the Republicans said that Kavanaugh was being borked. But my question is, so much of this comes out of the fact that they wouldn't give Merrick Garland a hearing. And now this rush to judgment to slam this guy in before next Monday, when they were perfectly willing to keep the seat vacant for over a year. How do we combat that? You know, this egregious double standard. What can we do about it?
Well, I think one way is to have rules, and one way to do that is to say, okay, each president gets 2 nominees, regular nominees. That's it. So, yeah, I mean, I didn't like the way the Republicans played hardball with regard to Merrick Garland. I think that will affect the composition of the court. But, I don't think the answer is vengeance going the other way. I mean, I think that when people thought Hillary Clinton was going to win, I think there were a lot of people who said, yeah, when she wins, we're going to pick the youngest, most liberal person that we can get. So we're going to abandon Garland and really go for someone we like so we can do exactly the same thing that the Republicans do. So I understand and I share to some extent the dismay about Merrick Garland, but I think we actually at some point have to get over it and try to come up with solutions that actually work for both sides. And I'm not sure both sides are willing yet to kind of call a truce and try to come up with something in the middle.
Gorsuch already got Garland's seat.
I'm sorry, what?
Gorsuch already got Garland's seat.
Right.
He got confirmed. So
Right.
to bring that up in the face of Kavanaugh, and I've had concerns about Kavanaugh from the refusal to release his paper trail to the lying in front of the Senate, and now this. It's just like he's the kid that keeps on giving you bad surprises. And so for them to say this is the Democrats getting revenge for Garland is just, my head could explode just because it really makes me annoyed, and it makes me feel so powerless for most of the people. Well,
the Republicans are very good at politics, as are the Democrats, occasionally. But at some point, it kind of seems like the Hatfields and the McCoys. I mean, you ask either side, they've got a list of complaints and grievances, and you can let the Hatfields and McCoys go on plugging away at each other, or you can say, we really, there has to be a better way than this, and there might be some aspects of it that we're not happy about, but this is just not working. And I guess until people are tired of doing the Hatfield and McCoy thing, then it's going to continue. But I think at some point we really need to start considering some more neutral means of doing this. But maybe I'm a naive optimist, or maybe that's why I'm not a political figure or elected. I've never been elected to anything.
Mr. Dane, you stated that ideology is inevitable, but that partisanship is not. So how would you suggest de-incentivizing partisanship in politics?
Oh, I'm not sure that we need to reduce partisanship in politics. I think it would be very healthy to reduce the sort of tribal polarization that we've developed in the political system. And there are any number of explanations for why our system has become so deeply, deeply tribal. And by tribal, I mean that people have a loyalty that transcends rationality and even transcends specific views of specific issues. So just to take Kavanaugh as an example, the fact that he's believed by most of the Republicans and disbelieved by most of the Democrats, if you think about it objectively, is very odd, right? You can easily understand why most Republicans would support him on his legal views, and most of the Democrats would oppose him, perhaps. But why most Republicans would see fit to believe him about a purely factual question of what he did or didn't do when he was younger, and that most of the Democrats would just sort of disbelieve him intuitively. This isn't, I think they're being perfectly sincere. This is not lack of sincerity. It's just a sort of instinctive sense of tribal loyalty. The people on your team have to be right. The people on your team have to be righteous and just. So in politics, I think a partisanship is part of politics. Polarization doesn't have to be. I think that neither polarization nor partisanship should be part of certain pieces of our system of governance. That's what I was trying to emphasize. So neither partisanship and certainly not polarization should be a feature of how we think of the courts, or how we think of the way we run elections, or how we think of the way we draw district lines. There should be islands of sanity that somehow anchor what can be a necessarily raucous political process. So there are really two issues here, right? There's partisanship, which in most cases just comes with the territory. There's polarization, which I think is a real problem in our country at the moment. And then there's the need for certain institutions and certain processes that are just left to do what they need to do professionally. And we've lost the ability to recognize the importance of that. And that's, as I said at the start, that's just bizarre. It is truly, truly bizarre.
Let me just say that decisions by experts based on professional knowledge, kind of sounds great to me. I mean, I'm a lawyer after all. And I read you that quote from this 1935 opinion, which kind of reflects that. Yeah, we got to have these institutions that have no policy but the policy of the law. I mean, it kind of sounds like a court. I think the problem is that you can't have certain decisions without underlying value judgments. And the people have to be accountable for those underlying value judgments. So yes, I mean you can make drawing district lines more impartial, but at some point there are going to be value judgments there. There are going to be value judgments with regard to precedent, whether precedent should be overruled or not overruled. There are going to be value judgments with regard to if you have a judicial nominating commission, what sorts of people you're looking for. Those cannot be made in a value-free way. So in a democracy, I think there has to be a way for the people making those decisions to have some sort of accountability. And so that's a little bit of my pushback to kind of rule by experts, is that it's an appealing vision, but I don't think that ultimately at the end of the day we can go completely along those lines. And I guess I'll end with my own kind of Anglophile thing, which is Winston Churchill. Winston Churchill said, democracy is the worst form of government except for any of the other types that we have. All right, so it's messy, it looks ugly, and I think we've gone overboard with the polarization, but I don't think we can have a lot of value-free decision-making bodies.
So I think on that note, we're going to close the program tonight. see you back here on October 18th, when our program will be on what appears to be the declining middle class. And we have two great economists coming, and I think you're going to enjoy that program. So good night, and thank you.